It's a then a famous speech. I want to quote from it because it also kind of reminded me that the sort of high-flown rhetoric that we see today isn't brand new anyway. So here's quoting Ted Kennedy's speech. Robert Bork's America is a land in which women would be forced into back-alley abortions. Blacks would sit at segregated lunch counters. Rogue police could break down citizens' doors in midnight raids. School children could not be taught about evolution. Writers and artists would be censored at the whim of the government. And the doors of the federal courts would be shut on the fingers of millions of citizens for whom the judiciary is often the only protector of the individual rights that are the heart of our democracy. Well, maybe. Bork's nomination was followed, most notably, by that of Clarence Thomas, of course, in 1992, where Americans really, for the first time, I think, paid attention to confirmation hearings in large numbers. How many of you remember the Thomas hearings? How many of you remember watching part of the Thomas hearings? It was transfixing, wasn't it? It was really quite transfixing in what now seems like a comparatively mild misconduct, frankly, oddly enough. Remember Professor Anita Hill, who actually visited Moscow at the invitation of the College of Law a couple of years ago now, charged Thomas with creating a hostile work environment at the EEOC when they both worked there through crude jokes, references to pornographic films, and repeated unsuccessful attempts to date her. Thomas was ultimately confirmed 52 to 48. Now, before I turn to the Kavanaugh confirmation, which is my third topic of the evening, I think it's worth mentioning that for all of the time and effort and politics and controversy that can surround the selection of a justice, once that justice is confirmed, there's really no telling where that justice will go. Justices often have a way of becoming their own person once they sit on the court, and largely acting beyond the reach of the political branches and disappointing the hopes of the presidents who selected them. To cite a recent example, Justice David Souter was nominated by the first President Bush to replace the retiring William Brennan. Now, William Brennan was a liberal icon, and conservatives could not wait to get rid of him. So Justice Souter came to the attention of the first President Bush through the White House Chief of Counsel and former New Hampshire Governor John Sununu, who promised that Souter would be a, quote, home run for conservatives. Well, that turned out to be not quite true. Although Justice Souter initially voted quite often, and most often, with Justice Antonin Scalia, who did indeed take a conservative view of many matters that came before the court, Justice Souter eventually joined what was considered to be the liberal wing of the court and stayed there consistently thereafter. And this would not be the only example of a justice who ended up disappointing the president's hopes for that justice. In 1902, Theodore Roosevelt named Oliver Wendell Holmes as his first appointee to the Supreme Court, delighted with the idea that he had found a justice who would take Justice Roosevelt's progressive view, and particularly in curbing big business. Then 20 months later, Justice Holmes voted against President Truman in the biggest railroad trust-busting case of the time, United States versus Northern Securities, prompting President Teddy Roosevelt to proclaim, "I could carve out of a banana a judge with more backbone than that." Then President Dwight Eisenhower said of his choice for Chief Justice Earl Warren, "the biggest damn fool mistake I ever made," partly dismayed by Warren's leading the court in the unanimous decision in Brown versus Board of Education, among other sins. And then just to cite one final example, President Harry Truman became very disappointed about his appointment of Tom Clark to the court. Tom Clark had actually originally been Truman's Attorney General, and Truman elevated him to the court partly because he, in Truman's view, Clark was doing such a poor job running the Attorney General, so he kicked him upstairs. So Justice Clark then ends up voting against Truman in the Steele seizure case, and prompting President Truman to say, it isn't so much of Clark, it isn't so much he's a bad man, Truman later told an oral historian, it's just that he's such a dumb son of a bitch. If that's Harry Truman, I don't know Harry Truman. But seriously, I do think it is important to note that justices do often become different after they join the court. They no longer necessarily feel beholden to the political powers that brought them to that place. And I say this partly based on experience. In my practice before the U.S. Supreme Court, both when drafting briefs and preparing for oral argument, I always approached it as believing, and I found this belief to be confirmed, that the justices had viewed themselves as judges first and foremost. I mean, part of their self-perception was of themselves as judges and not simply political cronies or hacks who got the job through, often through their political affiliations. So they took their independence pretty seriously. No question, they did bring ideologies to the court. I would say that of Justice William Brennan, among other people, and Justice Thurgood Marshall, as well as Justice Antonin Scalia. And no doubt Justice Kavanaugh brings a certain ideological approach to the court. But I think it's too simplistic to think of the justices simply as politicians in robes. And I'd also kind of to provide a little more context for it, just because a case gets to the U.S. Supreme Court, that doesn't necessarily mean it has an ideological valence to it, or really a political dimension to it. A lot of the cases that the U.S. Supreme Court takes are cases in which the lower courts have disagreed about the right way to interpret an act of Congress or a provision in the U.S. Constitution. And in these situations, the court steps in to bring some resolution and finality. Now, sometimes those issues that do need a resolution are really comparatively inconsequential. And if you learned about them, and if you heard about them, you wouldn't necessarily be able to say, oh, the Republican appointees will vote this way, and the Democratic appointees will vote that way. Indeed, these were the arguments that, the non-political cases were the arguments that low-level members of the Solicitor General's office, like myself in my former life, were assigned. The ones that didn't matter all too terribly much, the ones where the Solicitor General was not hearing from the White House. The first case that I ever argued before the Supreme Court involved some research monkeys who were the subject of experiments being conducted under a grant from the National Institutes of Health. And long story short, a lawsuit was brought against the federal officials who had custody of these research monkeys, and it actually was begun in the Louisiana State Court. And the federal government hates litigating cases in the state courts. They always try to remove them and transfer them to the federal courts. And the federal court decided it couldn't hear the case. There was a dispute about this issue of whether cases like this could be transferred from the state courts to the federal court. It needed to be resolved, so it went up to the U.S. Supreme Court. And because everyone in the Solicitor General's office was certain that the federal government would lose the case, it was assigned as the first case I would argue, a sure loser. And I was happy to have a sure loser because, you know, it meant that nothing that I could do would necessarily bring victory. One of the later cases, after I was there a couple of years, I got to argue another case that actually involved whether people who catch chickens on farms could unionize. It was the question of their status under the National Labor Relations Act. So I argued that case as well. And the joke in the office became that I was climbing the food chain. And eventually, if I got a experience and I did well enough, they would give me cases involving real live human beings. I'm happy to say I made the cut finally.